In this video, we talk about why you should never roll your 401k into an IRA without first understanding this lawsuit trap that you could be getting into. Coming up next on Holy Schmidt.
Holy Schmidt!
In life, there are rules that don't make a lot of sense, but we need to follow them anyway, otherwise something bad will happen to us. Why is it, for example, that your passport has an expiration date, but you can't use it 6 months before the expiration date? Or why is it that when you receive a bank check, it actually expires? Or why is it that when you roll your 401k into an IRA, a lot of the protections that were there against lawsuits and other things disappear? We're going to talk about that next. Let's start off with what a 401k actually protects you from, because most people never think about it until a problem shows up. Your 401k has some of the strongest creditor protections anywhere in federal law. And that's the point. Your protections come from a federal law called ERISA, and ERISA governs employer-sponsored plans. And that single fact is why the protection is so strong and so consistent. It does 3 things. First, there's no dollar cap. Whether you have $20,000 inside your 401k or $2 million inside your 401k, a creditor with, say, a $10 million claim generally can't get to the money inside your 401k. There are a few narrow exceptions. The IRS can get in, a divorce court can divide it through a qualified domestic relations order, and criminal restitution can reach it. But for most of the things that people find themselves in, most of the lawsuits that people find themselves in, they can't get inside your 401k. Second, it sits completely outside of the fight. Most of the other things that you own, your house, a brokerage account, your savings, can be pulled into a lawsuit, but they can't generally touch your 401k. Third, it applies in every state because federal law overrides state law. So it's just as protected in California as it is in Florida, as an example. Now, it's important to understand why this protection is so strong. When Congress built ERISA laws, they wanted to do so to protect the retiree from creditors along the way. Imagine over the course of 30 or 40 years, if someone gets in a lawsuit or 2 or 3, and there's this big pot of money there, they can go after it. ERISA generally protects that from happening. Now, I'm going to use 3 specific situations during this video, and you're going to see where the protection holds up and where it doesn't. The first is when a neighbor walks up your path, steps on some loose pavement, falls and breaks their back, and sues you for $3 million. The next is when a business deal goes sideways and one of the partners that you work with sues you for $2 million. Third, a parking lot argument turns into a physical altercation and the other party is seriously injured and they sue you for a lot of money. While that money is inside the 401k, it can't be reached. Now, all 3 of the examples are involving a lawsuit, and most people consider the lawsuit the arena that they worry about. But there's another arena, and that's bankruptcy. A lawsuit and bankruptcy are different, and the law treats them differently, but here's an important point. Your 401k is also protected in bankruptcy. That double shield is exactly what can change the moment you roll your 401k into an IRA, and that's what we're going to talk about next. Now, one point before we move on, I'm a CPA, I'm not an attorney, and what we're going to talk about is state law next. So use the information as a roadmap, not a final answer. If you're involved in a state-specific situation, make sure that you contact an attorney to talk to them about your options. When you roll your 401k into an IRA, your protection can shift from federal protection to state protection. And here's the part that confuses a lot of people. When you retire, what's the first thing that they say? Take your money out of your 401k and put it into an IRA because you'll have better investment choices and you won't pay the fee that the 401k was charging the pool. But when you roll your 401k to an IRA, at that moment, you leave federal protection and move into state protection. Now, when it moves to state protection, the toughest category that a handful of states have adopted is what's called reasonably necessary. What is reasonably necessary? It's when a judge determines what's reasonably necessary for you to live on your IRA. The judge looks at your whole picture, your age, your health, your other income from Social Security, a pension, or rental property, and decides how much of the IRA you genuinely need to live on. Whatever the court decides is more than you actually need to live can go to the creditor. And that's a huge difference. The same $1 million balance in an IRA for someone who's 75 and no other income can be completely protected. Someone who's 60 and working part-time can lose part of that balance. California courts, for example, have allowed creditors to reach hundreds of thousands of dollars inside an IRA. It actually happens. So let's go back to our 3 examples in a needs-based state: the neighbor, the business partner, and the altercation. In all 3 situations, the judge determines how much of your IRA you get to keep. Inside the 401k, the answer was a flat no. Inside the IRA, the answer is it depends. And then there's another wrinkle. Some states will give a regular IRA full protection, but will give reduced or no protection for a Roth IRA. Alabama, California, Georgia, Maine, Mississippi, Nebraska, and West Virginia, according to Alper Law's April 2026 review. If you live in one of those states and you're planning a Roth conversion, it's worth putting that math on the table right next to whether or not you should convert your Roth for tax purposes. Gang, if you're still using spreadsheets to manage your finances, you're doing it the old-fashioned way. Now, on this channel, we have 3 affiliate relationships. One is Bolden Personal Financial Planning Software. That's the personal financial planning software that I personally use. You can use Bolden to look at things like Roth conversions, Monte Carlo simulations, and a whole host of other scenarios that can help you make better decisions. If you'd like to try Bolden for free, you can go to go.bolden.com/Schmidt, and you can try their full-featured software free for 2 weeks. After that, it's just $12 per month paid annually. Now, let's be fair to other states, because it would be easy to walk away from this video saying, you know what, unless I'm in Florida, this is a non-starter for me. But that's not the case, because many states have dollar caps. They protect your IRA up to a dollar amount, and anything above that line is fair game. Nevada is a good example, and it's one that people get wrong all of the time. Under an old Nevada statute, the line was $500,000. Under the new one, it's $1 million. The $1 million is the present value of the IRA, and it even extends to inherited IRAs. For most retirees, a $1 million cap covers their entire IRA and then some, so Nevada isn't the cautionary tale that it used to be. Some states have lower caps, much lower than Nevada, and it would be impossible for me to go state by state on this video. Frankly, states do change over time. Using Nevada as an example, if you're lucky enough to have $1.4 million in your IRA and you have a $400,000 lawsuit, the first $1 million is protected. That $400,000 is fair game. The takeaway, by the way, is simpler and more useful. Just understand what your state protection limits are, whether it's full protection, a dollar cap, or needs-based. Understanding that is step 1 to protecting yourself. Now, there is an exception for bankruptcy. It's called the rollover protection, and it's very specific, so you need to really make sure you understand how this works. Here's the rule. When you roll your 401k into an IRA, sometimes called a rollover IRA or a conduit IRA, you retain that unlimited protection in bankruptcy as long as you don't add additional funds to that IRA. The federal bankruptcy code lets you treat those funds as if they were still sitting in that 401k. 2 conditions need to hold, though. The first is that it can only contain 401k money. The second is that you can't add any new funds. And by the way, investment growth is fine. If the account doubles over time because the investments have done well, the entire amount is protected. Buying and selling investments inside the account is also fine. The one thing that you cannot do, though, is add any new money. Because here's what happens. Say you have $3 million in your rollover IRA, and you add $8,000 because you think it's a small amount and I want to contribute to the IRA. That one $8,000 deposit can put the bankruptcy protection at risk. The concept is something called tracing. And basically, once you put in new money, it's hard to trace the performance of the new money versus the old money. So because of that, the assumption is that everything is in play. And when this happens, the bankruptcy court may treat the entire IRA as a contributory IRA. Now, I use the word may instead of will because a lot can happen. And just to round this one out completely, a contributory IRA is protected in bankruptcy up to $1,711,975. for 2025 through 2028. And rollover dollars don't account against that cap. But if commingling funds strips the title of rollover, all of a sudden you have $1.3 million of exposure in that $3 million rollover. And the big limit, to be super clear, the rollover protection only applies in bankruptcy, not in lawsuits. Now, on the strong end, there are about a dozen states that offer unlimited protection. And it looks a lot like a 401k and the protections of a 401k, but the wiring is different. Based on the current Alpert Law's state-by-state review, these states include Florida, Texas, Washington, Illinois, Connecticut, Indiana, Iowa, Kansas, New Jersey, New Mexico, Oklahoma, and Oregon. Florida and Texas get the most attention because they're both very popular places to retire. In Florida, Statute 222.21 is one of the strongest in the country because it covers IRAs, Roth IRAs, SEPs, Simples, and rollover IRAs, and even inherited IRAs, all with no dollar cap. If you run those three scenarios in Florida, a lawsuit can still be filed, a judgment can still be levied, but when the attorney goes to collect against the IRA, he or she will be shut down. So when you're thinking about where to retire, creditor protection should go right up there with property taxes and income taxes. And the view, of course. Also, think about your kids. In most states, the moment your children inherit your IRA, it loses its protection from their creditors. A divorce, a business lawsuit, or a bankruptcy of theirs can reach it. Florida is one of the few states that protects an inherited IRA the same way it protects your own. If you look at this in practice, let's say that your daughter is going through a rough divorce and she has a $500,000 inherited IRA. In most states, that $500,000 is on the table, but not in Florida. One practical rule, if you're thinking about relocating for this, is that under federal bankruptcy law, there's a 730-day rule. The state whose protections you can claim in bankruptcy is generally set by where you lived for 730 days, 2 years before you file. So you can't move to Florida a month before you file for bankruptcy. It just doesn't work. But this is a bankruptcy rule. It's not a general creditor rule. Gang, how prepared are you for retirement, really? A lot of people think they're more prepared than they really are. That's why I created the free retirement readiness quiz. It's 15 questions. It takes 2 minutes. It's totally free. No credit card, no phone number, nothing like that. You simply go to holyschmidt.com/quiz, fill out the 15 questions, and you get a 12-page report emailed to you instantly. You'll also be put on our list and get tips, tricks, and other information 2 or 3 times a week. Now let's talk about a cheap first layer of protection that works in every state. That's an umbrella policy. Umbrella insurance is excess liability coverage that sits on top of your auto and homeowners policies. When someone sues you, those base policies pay first. When they hit their limit, and in a serious case they will, the umbrella kicks in and covers the rest. The pricing is quite reasonable for what you get. A $1 million policy averages around $383 per year, and most land in the $200 to $400 range. Each additional million typically adds $50 to $75, so a $2 million policy runs about $474, and a $5 million policy about $608 on average. For context, that's about the cost of one dinner out per month for a couple for a $5 million policy. Now, when we look at the scenarios one more time, at least the scenario where the neighbor falls and breaks their back, your homeowner's policy would typically cover the first $300,000 and your umbrella policy would cover the rest. So if you had a $5 million policy and you got sued for $3 million, the umbrella policy would cover you in that scenario, more than likely. And here's why retirees are especially worth an attorney's time. They have the most money, generally speaking. By the time you retire, your house is paid off. You've got big balances in your investment accounts. But notice the limits because they do matter. A business lawsuit generally isn't covered. An altercation probably isn't covered. Someone slipping and falling on your walkway is probably covered, under most scenarios anyway. So here's your action list. First, understand what coverage your state offers, whether it's full protection, capped protection, or the judge can determine how much you need protection because each one of those matters. Also check for a Roth and an inherited IRA, not just your normal IRA. Second, check out umbrella policies. Many advisors recommend getting an umbrella policy for your entire net worth. Third, think very carefully about rolling your 401k into an IRA if you live in a state that offers needs-based decisioning. Fourth, if you do decide to do a rollover, make sure you use a dedicated rollover IRA and never contribute any more money to that IRA. Fifth, if you're planning on leaving money to your children, ask your attorney about a properly drafted trust. Sixth, if you're planning a move, make sure that you add creditor protection to the top of your list of things to consider about the state. If you like this video, check out that video. Most retirees don't know that this Roth conversion window expires after 2028. Also, don't forget to check out Bolden for your 2 free weeks. Go to go.bolden.com/Schmidt and you can get your 2 weeks free. This is Jeff Schmidt, and I will see you in that video right there.